May I go, Your Honor?
Yes, you may.
Good afternoon, Mr. Hunt. Did you, with regards to the advertisements that were introduced today by Mr. Lawson on behalf of the Florida Attorney General, did you prepare those, download those ads yourself to make sure they were full and complete?
Yes, sir, I did.
Okay. And you didn't crop anything from any ads because the Florida Attorney General wouldn't introduce evidence that had been cropped or altered, correct?
No, sir.
All right. Let me ask you to look at what we're going to mark as petitioners number 1, which is an ad, My Daily Moment. And would you look at the top, and this is a landing page, correct?
That's the ad.
This is the ad here, the landing page ad, is that correct?
Yes, sir.
All right. Now, you've been going through what we call the metadata of these ads, and have you gone through the metadata? Because I don't see where the advertisement part of this ad is included in what you introduced in the court. Was that inadvertent?
I didn't go through all the source code, Mr. Chairman.
Advertisement on it?
It still does.
Okay. There's source code that provides for that, correct? You didn't do that on purpose?
No, sir, the software grabs it just the way it appears.
Now, let me ask you this, sir. Would you agree that WAM provides access software or provides or enables computer access by multiple users to a computer server such as AOL, ESPN? Would you agree with that they provide? So you don't know that one way or the other?
I have a basic concept of what it is and how it works, but I don't know who has what portions of it.
You don't have any evidence to dispute that WAM is an access software provider or that they provide or enable computer access by multiple users to a computer server. You don't have any evidence.
One way or another, Mr. Chairman.
You don't have evidence to offer on that point, correct? All right. Well, when people would access ads where WAM is the ad agency, it would be accessed through software by multiple users who would go to AOL, weather.com, etc. You would concede that point, would you not, sir?
I don't have the knowledge to dispute or refute.
All right. And do you have any familiarity with the CDA Section 230, which is the preemption statute?
No, sir.
Never read it?
No, sir.
Don't have any knowledge of it?
No, sir.
Now,
I know what it is, but I'm not aware of an investigator, so it didn't apply.
no, so I understand, yeah, no doubt. So no evidence to suggest that WAM is not an interactive computer service provider, correct? And all of the ads and all of the copy that you've been shown to the court today, which the Attorney General's introduced, you don't have any evidence, do you, sir, that WAM wrote that copy, do you? That they sat down and drafted the copy and the ads? You don't have any evidence to show that, do you?
No, sir, that's why we're performing the investigation.
All right.
Don't those emails show that?
No, sir, I'll get to them, Judge, and I'll ask about that. I think they show the opposite.
Okay.
And you don't have any evidence, do you, sir, that WAM was the publisher or speaker of that content, do you, sir?
I don't understand the question.
Well, I'm reading it from the statute. That you don't have any evidence to suggest that WAM was the speaker who spoke the words or prepared the words that appeared on those pages, do you, sir? You have no evidence.
That's why we're conducting the investigation.
Right. Would say to their attorney, ads that say, should we run them or should we tell them that we're not going to run them? You weren't aware of that, were you?
No.
And you find nothing wrong with that, do you?
Your Honor, I have to
One
check.
way or another. I'm opinion on one way or another.
Your Honor,
I'd object to general questions asking for a legal conclusion from Mr. Hahn.
Well, he's a case agent, but I'll withdraw that. All right, so then let's go down just one more time so it's clear. WAM sends to Derek Young and asks him, what do you think about the above? You don't have any evidence at all on any of these ads that anybody from WAM wrote the copy, do you?
No, sir. That's why we're still investigating.
Geo-tracking is what, sir?
Geo-tracking is basically, the way it was explained to me, again, in my limited knowledge, that geo IP tracking is running an ad, identifying a particular city or a person from a particular city, and manipulating that within the source code, which is geo IP.
Right. And did you know that Facebook geo-tracks? Were you aware of that?
No, sir.
Okay. Are you aware that AOL geo-tracks?
No, sir. We're still investigating a number of different issues.
And you can't tell this court today that geo-tracking is false and deceptive.
That's a decision for the courts.
Of this case, correct, sir?
One of them.
All right. Now, if in fact the CDA 20230 preempts a claim under the FTC 501.206, you're not aware of any other statute as a case agent that would allow the Attorney General to serve a subpoena, are you, sir?
That's a legal question for an attorney.
I'm asking if you're aware of any other statute as case agent.
Your Honor.
Okay, finally, were you aware, sir, that on July 13th or 23rd, that PM Bondi signed a letter saying that, in fact, she contended that because of the CDA, Section 230, that she had no jurisdiction over internet advertisers. Were you aware of that letter, sir? All right. You've seen it, though, I take it. Have you not, sir?
I haven't even read it.
Your Honor, the letter speaks for itself. I think Mr. Andrews would have submitted that.
Well, I'll submit it now as the next exhibit. And so then I will, Judge, submit Ms. Bondi's letter, the NAG letter as exhibit.
6, 5 or 6, I forget which. 6.
Well, the court, I know it's a difficult one, and I know that it's a matter of great public importance. Is Canada's Attorney General, and they've acknowledged that they don't have, that the preemption applies, and it requires an amendment to the statute. That's what they've said, it requires an amendment to the statute for them to, Judge, and I have to say that it's always the argument is the porno or the pernicious crimes, which we can all agree, I think, need to be stopped. No one suggests otherwise. However, that to the extent that you allow them to serve subpoenas on anyone that has a prima facie showing of preemption, then you've opened up this broad door that's going to have a chilling effect on advertisers. It's going to have a chilling effect on websites, because if you try to police it internally, okay, which my client's evidence is clear that they have, then what you're doing is you're creating a series of facts that will be used against you to say that you changed the content or you engaged in solicitation by simply trying to tell your customers, hey, we're not going to run this ad unless you change it. And so the real question is, what showing does the Attorney General have to make in order even to serve such a First Amendment chilling subpoena? And I would suggest to the court that they have to make that showing first because of the high stakes involved. And the two cases I cited to you, Judge, which the AG cited, which was Village Minor and Backpage.com, I mean, they go into that. And in one of those cases, they charged an internet advertising company for advertising child pornography. Obviously, horrible, pernicious crime. However, court ruled that even in that instance, the advertising of the porno on the internet was declared preempted by statute 230. So it is a very difficult call, because I can imagine how the court wants to allow the full and free investigation of what it may consider to be pernicious activities, which we can all agree. However, the chilling effect of the First Amendment, the chilling effect on the internet, and the chilling effect it's going to have on a whole industry.
What about the Jackson case? They specifically said that the First Amendment issues have to be dealt with in a later lawsuit, not on the administrative, not on the investigative subpoena.
I don't think, Judge, that Jackson really addressed the preemption argument.
Oh, yeah, I agree with you, it did not address the CDA, but it did address First Amendment religious freedom defenses that were raised against the subpoena, and basically they said, we're not saying that these defenses might not very well be good defenses if an action's brought, but they're not defenses to the subpoena.
The only thing I can say, Judge, is that some things are so sacrosanct that and one of them has traditionally been the free back and forth on the internet. And the Congress was cognizant of that in 1996 when they created these preemptions. And so what I think that the court should consider is the following ruling. That because there is a heightened scrutiny to policing a business that has traditionally been a business that has had no regulation, and there may be pockets that need it. But the chilling effect, if you're served a subpoena on the people who serve these ads, for example, without a clear showing that the exemption doesn't apply, it's going to have a very, very chilling effect on every one of these people. It's already affected my clients. And so to the extent that, and it's impossible to comply with, because there's so many ads that are placed. And their arguments, I know they're made in good faith, but they're just flimsy. I mean, when you look at the ads and their face creams or colon cleanse or whatever, I mean, maybe they're something, maybe they're not. Well, maybe they weren't. But I will say that this, Judge, is that it's a sacrosanct area, and you've got to protect the internet and the people that populate it. Because if you were serving these subpoenas on a newspaper, for example, the St. Pete Times, without any probable cause, without any reason to believe, without anything like that, it would have a chilling effect on having that subpoena sit out there, especially in light of the letter that was sent this summer by NAG.
Well, I will note that both the Jackson case, decided in 1991, and the CDA passed, what, 95? 96? Were both, the case was decided and the CDA was passed at a time when the internet now bears probably no recognizable semblance to what was in existence in 1991 or 1996. So where does that leave us?
I think it leaves.
Because I think a lot of this stuff didn't even exist at the time. I guarantee you cell phone ads didn't exist at the time.
Well, I think, Judge, that
And this magic face cream probably hadn't even been invented by then.
I don't think that if the internet existed when I was in 8th grade, I would never would have left my bedroom after 8 o'clock at night. So things have changed. But the fact that it's changed, I mean, you can just look at the Tallahassee Democrat, and you can see it get smaller and smaller and smaller. You can see that this is a free-flowing marketplace of ideas, and if they start, you have to trust the good faith of the state when they serve subpoenas, and the court rightly found they have to make a showing.
So you're saying this subpoena is really an attempt at over-regulation by the state of Florida?
That's what I'm suggesting is that it is a backdoor attempt to start to regulate. And by allowing the subpoenas to be served on these companies without some showing that the preemption does not apply to them, and I would submit to the court they made no showing, that you are either trusting big government and their various political winds that toss them back and forth, or you have to say, I'm going to stand up for the First Amendment, I'm going to stand up for free-flowing ideas, and I'm going to let Congress fix this if there's a fix to be permitted. Because otherwise, we could get subpoenas from Mississippi, we could get subpoenas from North Carolina, we could get subpoenas from everywhere. And then all of a sudden, it starts to turn the spigot off of free speech. And it's a hard case. And I know the court will make a recent decision, but if you do allow the subpoena to be served, I'd ask that you request that the first DCA certify it as a matter of public importance. And I would say that the Florida Supreme Court case does say the CDA preempts state law. Now, it says state common law.
Yeah, that was a lawsuit, as I recall.
It was defamation.
Defamation.
And it didn't say state law, because had they said state law, we wouldn't be having this discussion. But they said state common law.
Judge Lewis, Judge Perrienti, and one other judge dissented on that.
Judge Lewis, I know, dissented. Judge and I.
Judge Perrienti, I forget, there was a third judge.
I know that I only got to Judge Lewis, and
Yeah.
I was surprised that he dissented in a way, but I guess I respect all three of those Supreme Court judges, and it's a funny weather vane for politically, because you would expect one result from a Supreme Court populated by those specific individuals than what was given. However, where the battle's going to be fought, it's going to be fought right here in trial courts. And I believe, Judge, that because of the potential perniciousness of a Attorney General, State's Attorney General, to serve subpoenas for improper motives, serve subpoenas that are not grounded in statutes they can enforce, absent a showing of no preemption, then I believe that the court should stand for the proposition that the internet's different. The internet is a different breed of cat, and it requires, if we're going to change the law, then let the Commerce Committees in the House and the Senate do it. But otherwise, people are going to be paralyzed. I mean, my clients, we get, like I said earlier, I think the case manager, we've been jawboned into regulating. And so what happens is the impact is disparate. If you try to regulate yourself, then all your competitors steal your business. So that's the problem. It's like, hey, I made a mistake, so sue me, because we try to comply. What happens is, it's the people who don't comply. But the big picture is, there's no way you can comply if you're serving 50 or 100 ads a day, and that's what Congress recognized. So, if you imagine a world where all these internet companies are served investigative subpoenas, and the lawyers get a chance to pencil whip them, then the internet will change. The free flow of ideas will change. And the effect of it will be a detriment to all of us. That's what I would say, Your Honor. And if you do the rule, please sort of